Good afternoon. Hi, I'm Carrie Hunt, NAFCU's General Counsel and SVP of Government Affairs. And today, like many days, I want to talk about interchange. This video is a little bit different because we definitely have some good news coming out of the U.S. Court of Appeals for the District of Columbia Circuit. Earlier today in the morning, the appellate court overturned that lower court ruling on interchange that would have had a very drastic impact on all credit unions. So in case you missed it, let me bring you up to speed. Several trade associations on the merchant side brought a suit relative to interchange to invalidate a Federal Reserve rule that had implemented the Durbin Amendment. That rule set a limit on the fees financial institutions can charge merchants for processing debit card transactions and required issuers to make available 2 unaffiliated networks for each debit card. And NAFCU and other financial trades filed an amicus brief in that matter, arguing that the fee cap imposed by the board was too low rather than too high, as argued by the merchants. Well, the district court completely sided with the merchants in that lower court decision and said the law of the land was crystal clear and that the Federal Reserve had included a whole host of costs it should not have in that 21-cent cap. The Federal Reserve appealed at our urging, and we filed an amicus brief in the appellate level as well, not because we necessarily thought the Federal Reserve had gotten it completely right in their rule, but because that lower court decision, if it had been really upheld, would have a drastic impact on credit unions and other financial institutions and would have required 4 separate networks for each type of transaction, and the interchange fee would have shrunk dramatically. Well, today the appellate court gave a resounding opinion that they thought the lower court got it wrong and that the Fed was reasonable in putting out the rule that it did. Now again, we still think that the Federal Reserve could include more costs in what it did in its rule, but what we have now certainly is better than what the result would have been if that lower court decision had stood. So let me take just a second and talk about a few key points. First, the appellate court ruled in favor of the Federal Reserve on almost everything. There were a number of separate issues that the court had to consider, and they really did rule in favor of the Federal Reserve on almost all of them. There was one area where they thought there needed to be a little more explanation, though. The one element of that 21-cent fee cap that the Federal Reserve created included transaction monitoring costs. And the court said they didn't think the Federal Reserve did a good enough job in explaining why that should be considered in that 21-cent fee cap, as opposed to why transaction monitoring isn't really a fraud cost. And under the Durbin Amendment, only certain fraud costs are allowed to be included in the debit interchange cap. So on that matter, there's going to be some further discussion. The court wants the Board of Governors to better explain why they really came up to the reason that they did. And that's very common in this type of law. Really, when courts look at what regulatory agencies do, they're supposed to look and see whether or not the agency had a reasonable and a rational reason for doing what it did, and whether or not it explained it well enough. So in this case, the court said, well, we're going to give the Fed the benefit of the doubt and say that we think they could have come up with what they did, but they really need to go back and explain it a little bit better. So we will see something on that in probably the next few months. Now, relative to interchange fees, everything is status quo. That's extremely positive, of course. And relative to network exclusivity, the appellate court maintained the non-exclusivity provisions of the board's current rule. So that means credit unions do not have to have 4 networks total. And if you're in compliance with the rule as it now stands, you can continue to do what you have been doing. Just as the appellate court, the district court was very critical of the Federal Reserve, this opinion had a little bit of color in it as well. The court expressed displeasure with the Durbin Amendment in general and said that Congress put the board, the district court, and us in a real bind. It's perhaps unsurprising given the Durbin Amendment was crafted in conference committee at the 11th hour. Its language is confusing and its structure convoluted. But regardless of that, the appellate court, again, thought that that statutory language allowed the Federal Reserve to do what it did. So what happens next? Well, as I said, we'll see some addressing of the issue relative to how the board came up with their transaction monitoring costs. Otherwise, NAFCU will continue to monitor this issue. We will continue to press if the opportunity arises why we still think that the Durbin Amendment has a negative impact on credit unions. I will also mention that the merchants may appeal this decision. They can petition the court for a rehearing, or they can petition the Supreme Court as well. And certainly, of course, we will be looking for that. I will say, though, that the appellate court, in terms of its legal reasoning, really did rely on long-standing principles of law. As always, if you have any questions, please give me a call, 703-842-2234, and I hope everyone has a great weekend. Thank you.